This is the Court Leader's Advantage, a podcast series for court professionals and by court professionals. Brought to you by thecourtleader.net and in cooperation with NACM, the National Association for Court Management. The demand for workplace mediation is rising across America. Increasingly, organizations are recognizing workplace mediation as essential for resolving conflicts and fostering healthier work environments. In fiscal year 2024, the U.S. Equal Employment Opportunity Commission processed over 88,000 new charges. That is a 9% increase over the previous year. Market forecasts predict that mediation will grow by more than 7% per year between 2024 and 2030. The evolving nature of employment, including hybrid work arrangements and an increasingly diverse workforce, has introduced new forms of conflict. Forms that traditional HR or disciplinary processes may struggle to effectively address. There are several factors driving this trend in workplace mediation. Organizations are placing greater emphasis on employee well-being and mental health, recognizing that unresolved conflicts harm morale, increase stress, and drive higher turnover. Mediation is increasingly valued as a faster, more effective, less disruptive, and more humane alternative to formal grievance procedures or litigation. Technological advancements such as digital mediation platforms, remote sessions, and even AI-assisted mediation tools make mediation more accessible and scalable than ever. However, acceptance is not universal. Several concerns exist. Mediation only works if both parties consent. They must commit to open communication. They must trust each other and the process. Not all conflicts may be suited for mediation. Severe legal breaches, discrimination, harassment, or highly entrenched systemic issues may still require formal action. For organizations without proper training or resources, poorly handled mediation attempts might do more harm than good. Organizations often mistake managers skilled in conflict resolution for professional workplace mediators. This is a confusion that can have serious consequences. Unlike managers who address conflicts through authority and organizational interests, workplace mediators are neutral. They are trained facilitators who guide parties toward voluntary resolution without bias or having a stake in the outcome. Relying on managers as mediators can undermine trust, escalate tensions, and reduce the likelihood of sustainable, agreed-upon solutions. I'm Pete Kiefer, and welcome to the Court Leader's Advantage podcast series. This month, we're exploring workplace mediation. Is the concept of resolving workplace disputes using trained neutrals more effective than what organizations traditionally use? And most importantly, can it work for the courts? Here to moderate today's discussion is Erica Schmidt, Judicial Clerk Supervisor at the Multnomah County Circuit Court in Portland, Oregon. On today's panel are Tessere Kalicharan, ADR Director for the 9th Judicial Circuit Court in Orlando, Florida. Beth Moss, Human Resources Director for the Alaska State Court System. And Jamie Gianni, founder of the Third Branch Solutions in Wesley Chapel, Florida. Thank you all for joining today's podcast. So let's join Erica and our panel as they discuss workplace mediation.
Hello and welcome, everybody. Thank you so much for joining me today. Let's launch into some questions about mediation. So, news reports suggest that workplace conflict is increasing in the U.S. Based on your experience, how have you observed workplace conflict evolving over the past few years? Let's start with you, Jamie.
I've definitely seen an increase, and I think there's quite a few reasons for that. Starting with COVID and going forward, people in the workplace have seen so many changes in the past 5 years. And, it's like feeling pulled back and forth. It increases your stress level and increases frustration. There's change fatigue. And then you're bringing so much to work with you, things that are happening in society, politics, societal divides. There's more generational conflict, I think, in the workplace right now with a new generation entering the workforce that has different values and ideals that don't always match up with older generations. And then you're talking about introducing a lot of new technology constantly. Things are changing very rapidly, but also you're talking about, in my case, when in working with the administrative office with the federal courts, introducing new philosophies like agile, which is a lot of people are getting on that bus. And change is hard, right? Like, and when you try to introduce things like that, and I think as Peter said in the intro, with more focus on well-being and psychological safety, that's all great, but it's not easy. It's not easy to convert to saying, okay, we're a psychologically safe environment, because that necessitates people being able to come, and this is kind of another buzzword, as their authentic selves to the workplace.
Yeah.
And when people do that, it may not always mesh cleanly, and that's okay. But workplaces have to find a way to disagree without being disagreeable, to have constructive dialogue, constructive disagreement. I think disagreements are good for the workplace. Diversity is good. Having the different perspectives is great. And it's up to the leaders in the workplace to make sure that they create a culture where that dialogue and disagreement is productive rather than destructive.
Absolutely. Beth, did you have anything else to add?
Oh, for sure. I mean, I can echo everything Jamie said. The pandemic, before the pandemic, we had personality conflicts, kind of communication breakdowns, but now it's more layered. People are dealing with burnout, change, and just like Jamie said, higher levels of stress, both at home and at work, and they're bringing it into the workplace. Also, just like Jamie was talking about the generational dynamics, we have more generations working together now than we ever have. And I think we see it a lot in the generations, the new generations coming into the workplace. They're all about texting, and they've never learned how to really communicate. And so you put them in a workplace and expect them to communicate with some of the older generations, and it's very difficult. And so through that, we see issues, and then remote work and hybrid work. You no longer have that in-person clarification. You can't just walk across the hall and say something. Miscommunications can kind of linger. So the conflicts that were in the past kind of not a big deal now are becoming a bigger deal, because we're having to find different ways to address those conflicts for those remote workers versus the in-person workers.
Valid points for sure. And I think it's a balance as well. Like you mentioned, like it's not just about like, oh, they didn't say hi to me this morning. That's a simple thing that we can resolve. I think it's when it gets to beyond just these small little quarrels, that's what we're really talking about here. So one key role for mediation is to create a safe environment where all parties can speak openly without fear. Given the inherent power differential that managers hold, can they effectively establish such a space? And how does this compare to the ability of a neutral mediator to do so? Jamie, I'm going to hit you up again.
I spoke a little bit about this, but that is a huge issue that I think that's an area where I think a trained mediator really helps, and it really is needed. And I think especially, and my background is with the federal system. And so it's not just about the power differential between the manager and the immediate employee, but I think there's also, and I can't speak for state courts, but I imagine that there's a similar dynamic. The culture is very judge driven. And so anyone within the system that has, if the conflict involves a judge, for instance, or even indirectly, if one of the parties is close to a judge, whatever it is, then there's a power dynamic there that may not be immediately visible to someone outside the system, but that's why you need someone, if not outside the system, outside the court, to come in and say, hey, here's what I'm seeing, because I think that's crucial for the trust element that we're talking about. Because there are historical things in courthouses. There's, different personnel, there's different divides. And when you bring all that with you and there's judges involved, that element of that power dynamic is just exponentially more, potentially more aggravating. And so I think definitely it would be very hard for a manager, not just because of their status as a manager, but because of the overall culture of the courts, to be able to effectively mediate a really tangled issue.
Yeah. No, and that's an excellent point. I think a lot of us think about any workplace conflict as between coworkers or somebody, maybe in different departments. But because we interact so much with judges and have judges as staff, they are right there with us as well. And I will say, as a clerk supervisor, where clerks are working with judges on a daily basis, that is a big part of conflict as well. You have a lot of different personalities happening in one building. So Beth, do you have anything else to add?
It's difficult to have managers turn into mediators, but it's not impossible. But really, for them to be mediators, they have to have created, some psychological safety. They have to have trust, consistency, fairness, and they have to build those relationships. Whereas a mediator, on the other hand, can come in, they have no bias, they have no fight in the game, and I think employees feel more free to speak. And so then the mediator can create more clarity and closure. And just to kind of talk about what Jamie was talking about, judicial officers, one thing that we're doing in the Alaska court system right now is we're currently working on a judicial training on how to be a supervisor, because we all know judges do not go to school to be supervisors. And so when they become supervisors, they honestly don't know what to do and struggle. And so we're really focusing on that for 2026. We will actually be issuing an order from the Chief Justice that all our judges will go through this training. And so we're really looking forward to seeing what kind of differences we can make with our judicial officers and our employees as well.
Oh, that's fabulous. I have a unique role where I supervise the clerks, but I also work with the judges. So they're with the clerks on a daily basis, but technically I supervise all the clerks. And I recognize that not every courthouse has that. So that is essential for judges to get that training.
So one
Yeah.
of the other things that popped into my brain as we're having this discussion is that the manager or a person from the organization being the mediator for something inside the organization to mediate, you can potentially run into a conflict of confidentiality, right? And so what if that employee is sharing something that happened during FMLA or something of that nature? You, the manager, you're compromised a little bit. Do you is this a reportable situation, not reportable? Because in the mediation process it is supposed to be confidential versus that third party retained mediator, right, who has again no stake in the outcome. There are no knowledge of the organization. It's just a matter about facilitating that communication for a resolution.
Yeah, and that's a great point on just unintentional bias. Like you don't recognize that you have that when you come in, but you still have it in the back of your mind.
If I could just jump in here for a minute.
Yeah.
We've worked really hard with our managers to create relationships with HR so they feel more comfortable coming to us when there are issues. And sometimes we play the role as the mediator rather than the managers. We kind of ask them to step out and let us do the mediation so that we are kind of that third party, neutral party. And we've seen, success with that as well. But we have also hired outside mediators when there's been issues too.
It's wonderful. All right, y'all get to spill the tea now. Can you recall any workplace conflict you've observed where the presence of a trained mediator might have changed the outcome? How might their involvement have influenced the situation? Jamie.
Outside of some of the exceptions that Peter mentioned in the intro, like just gross misconduct, illegal activity, harassment, those sorts of things, I think mediation could help in basically any workplace conflict, or it has the potential to. Now, would every conflict need it necessarily? No, but could it benefit from it? Probably. And so I could think of several specific examples. I won't get into the details, but like just, personality conflicts, for example, or I've had workplace conflicts where it it's like people aren't on the same page. They can't get on the same page, and you see them talking past each other. Or just like we talked about before, generational issues with communication, things like that. I think definitely a mediator coming in could help resolve some of those issues for sure.
Love that. Tess, do you have anything else?
Thank you. So I don't have any tea to spill, right? We've been very fortunate with the way we communicate here.
That's
But like what
fabulous.
Miss Beth had said, right, is that there's also a strong presence with HR and that working relationship between HR and the managers for that to be a very open communicating environment. And it's not just where HR has a presence with just managers, they're constantly providing training so the employees also know the things that they have a right to access or to ask the questions. And so it's been a cohesive type of communication. And then the managers, the senior managers, the executive managers, they have an open door policy that just allows that psychological safety that we're all looking for to be able to express the concerns or ask for feedback or give the feedback.
Yeah. And you guys raise absolutely wonderful points regarding HR and how important of a role they play and how vital they are for these instances. So does your court, HR, or state administrative office offer the services of an impartial mediator? And would such a service be valuable if you don't? Tess, I'm going to go back to you.
We don't initially have that service that's
Okay.
being offered as a third-party mediator because of the strong communication that we've been able to establish in court administration. If one exists, I don't know. Right. And I think it's topic specific too, like the level of the grievance that has occurred.
Yeah.
Yeah.
All right, Beth, how about you?
Yeah, we don't have a dedicated internal mediation program, though, like I was saying, HR plays a very vital role in that. But we have in the past, we had a situation with a department that was very toxic, and it had just kind of lingered for a real long time, and it kind of blew up. And so we brought in an outside mediator. HR stepped out, the manager stepped out, and we allowed that mediator just to talk with the employees. I think they met with each one separate, and then they met as a group. And we did see some changes coming from that. And again, it goes back to culture and how you're going to work to change the culture that you have. Because if you can change the culture, even if it's through a mediator, you're going to improve morale, retention, and employees are going to begin to trust not only their managers, but HR. And I think when we bring in those mediators, employees see that we care and we are trying to make changes that are positive for them.
Right. So is workplace mediation an area where artificial intelligence could play a part? Jamie, what do you think?
Yes. I mean, but I'll preface that by saying that I believe that AI will probably play a part in a lot of processes moving forward. I mean, it's going to become, for my prediction would be it's like the next internet or the next mobile phone. It's just that new wave of technology that's just going to become part of our daily lives. And so can it help? I think definitely. And I think even the American Arbitration Association has recently introduced like an AI arbitration model. So it's happening. And I think with all other things AI, it just has to be implemented responsibly and ethically and with some guardrails. So we have to be very intentional about how we're using AI in all lanes, but definitely with this one. And as with all AI, I think there always has to be that element of human discernment or judgment that's involved somewhere in the process.
Exactly. I always say use it as a base, but then build off of that with the human aspect. So Beth, what do you think as well?
Yeah, I definitely see AI playing a supportive role. I don't think
Yes.
it'll ever replace the human mediation, but I can see it as a way of like analyzing data within the workplace, like we do culture surveys and things like that. I think it could analyze, it could even possibly flag some early signs of conflict. I could see mediators using it as kind of a template for a guided conversation. So I think it's an enhancement, but never a substitute for the human person and the human connection. And I think
Yeah.
we have to remember that with AI, that we still need that human connection.
Yeah, exactly. And you also mentioned a good point that you want to anticipate it. And I think that's the biggest aspect. You don't want to get to a point where you have reached the point of blowout, and everything has gone everywhere. But Tess, what do you have for thinking ahead?
Yeah, yeah, no, thank you. So one of the pilot programs that we had here in the Ninth Circuit was an online dispute resolution pilot program for county mediations. And it took away the human aspect of the mediation process because it was a back and forth sort of chat situation,
Okay.
like for the offer, counter offers, negotiation process. But for workplace, it's very, very different because what we found in online dispute resolution is that the buyer's remorse percentage increased. You walked away and had moments to think about it versus in that moment with the human one-on-one interaction to immediately walk away feeling resolved or heard.
Right. So, does your court offer training in workplace conflict management? And if so, what kind of topics are covered? Tess.
Yes, the Ninth Circuit is very,
Okay.
very huge on providing employee trainings and manager training. So the topics that we
Good.
do cover every year, annually, and quarterly are like things with discrimination, the employee rights, expectations from the organization, retaliation training, and then they take it a step further by providing what the resources are available both to managers and the employee and what potential remedies may look like.
Wonderful. I think that's the key factors, knowing your resources. I have so many coworkers and staff and people in my team that just don't know what's available to them. And that is definitely a huge part. Beth, anything else to add for your court?
We have been very intentional over the last few years about building out some programs, not only for the managers, but for the employees. And so one thing that we rolled out a couple years ago was a civility training. And we addressed conflict and day-to-day interactions. We helped people understand the difference between being civil and uncivil. And not just like the yelling and the name calling, but some of the quiet behaviors, the eye rolling, the side comments, exclusion, maybe dismissive tones or the chronic negativity. And the goal of that was really to give managers and employees a shared language so that they could recognize, name, and address some of those conflicts as they arise. And giving the employees and managers an opportunity to say, it's okay to have a conversation about this. Hey, that's not cool what you just did. Let me tell you why it makes me feel the way it does. It's been helpful. It really has. Some of the other things that we do more broader from a management perspective is we have a 10-week management development course. And some of the things that we go through in there is communication and feedback. How to have those crucial conversations, how to have, those hard conversations without making it personal. We've talked about performance management and how it's okay to manage an employee, even though there may be some conflict there or something, you still have to hold them accountable, but it needs to be clear and consistent. Emotional intelligence and self-awareness, helping people realize triggers, and responses, and then early intervention. We've really encouraged our supervisors, like I was saying earlier, to reach out to HR, let us help, so that we can hopefully resolve the conflicts before they get to the point of explosion. And when you tie all these together, it really helps the environment. And we've seen a great change in our culture since we started doing this.
So last question for you all. What advice do you have for courts that might consider looking into experienced workplace mediators? Jamie, I'll start with you. Do it. I love it.
I mean, yeah, like I think that there's clear benefits, right? Besides not putting your employees and managers in awkward positions necessarily, we've talked about confidentiality issues, and with the increase, I think that we're seeing in workplace conflict, I think you're going to see benefits beyond just the immediate benefits, right? Like retention, higher employee morale. If you know that you have an option for a third party neutral, then you may be more likely to go to your manager or HR to report something. I know that again, speaking with the federal courts, that's kind of one thing that they've had to try to struggle to find a solution to, is people being unwilling to come forward because they don't feel like they have an adequate mechanism to report issues. And so I think that alone is huge, because you want to ferret out bad behavior. You want to address it before it festers or causes other issues. And so, I mean, I think it's a win-win.
Yeah.
So do it.
I love it. Tess, what about you?
Yes and no, a little bit. So like if a circuit is considering this option, I think it has to do with a high level of discretion on what that claim or that grievance may be. And if the circuit chooses to retain a third party mediator to go and try to resolve the situation, it shouldn't also set aside training the managers that are there, because I think that the managers who are there are the frontliners to be able to see, identify what potential issues may exist. And that training will not only empower that manager to do their job, but it will also empower the manager to empower their staff to build that healthy relationship. So it's both.
Yeah, it's a balance for sure. Knowing again, most supervisors and managers are the frontline person that's going to deal with that disgruntled individual from that instant of, just whatever happened 2 seconds ago, to the point where, say somewhere down the line things have escalated, then let's bring in, the mediator and have this resolved. So I think it's that balance between small instances and bigger lingering instances, but also having that training to hopefully not get to that point where we have those big instances. Right, Beth,
And
do
I'll
you
just
have
say,
Oh, yeah,
I
sorry.
agree. I just say, I agree with Tess. I think it has to be a multi-layered approach. When I say do it, I don't want to say for every conflict, because I think there does have to be discernment, but I think there's value in just having the option available. And I think even just having the option available may avert some issues.
Yeah.
So just wanted to clarify.
Absolutely. And it depends on the courts too. I'm in a relatively big court, so it's like mediation for us, very helpful, simply because there's so many people here, so many different departments, so many personalities to handle. But say a more rural court might not have as much conflict because there's not as many people, or they might have more conflict, who knows? So I think it really depends on where you are in the courts as well. Beth, anything else to add?
Think, you have to start small but be intentional about it. And if you're going to search out a mediator, I think one thing you really have to make sure is they first understand employment law, but they also understand your culture. Because if you bring a mediator in that doesn't know your culture, you may not get the results you want. And so I think it's important that you think about mediation early on, but again, just like everyone said, train your managers, set them up for success, have an open door policy with HR, where anyone feels like they can reach out and have conversations. And we worked really hard to let our employees know that we're a safe place to come. And I think when you do that, you start creating a healthy workplace, and it can change the entire culture from being reactive to more proactive. And then you may not even need the mediators. But I think, like I said, start small, but be intentional about it.
Wonderful points for sure. And I think that's the heart of it too, is we're handling and dealing with people. And people are going to have big emotions, and that's okay. I've always said that to my entire team. I'm like, you can feel your feels. That's important. So I think that's definitely the moral of the story, is everybody's going to feel their feels, but as long as we have the tools to set us up for success and be able to mediate when we can and when we need to, that's what's important. So thank you all for joining me today. It was a wonderful conversation with you guys.
A heartfelt thank you to Erica, Jamie, Tess, and Beth for sharing their insights and experiences on workplace mediation. It will be interesting to see how this concept evolves in the years ahead. And to all you court professionals tuning in today, thank you. Your unwavering commitment to excellence in service strengthens our courts and uplifts our communities. We are grateful to the work you do every day. Join us again on Tuesday, February 17th for another episode of the Court Leader's Advantage as we take on the issues shaping courts today. I'm Pete Kiefer, and thanks for joining us today. We'll see you next time. Thanks for joining us today. The Court Leader's Advantage is a regular podcast series on courts and court administration. Today's episode will be available on our website, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on Instagram. Did you enjoy this episode? Please share the podcast link on your social media pages. Every share helps spread the word about the vital work court administrators do to strengthen justice in our communities. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is CLApodcast, that's all one word, at nacomnet.org. Did you hear an interesting comment by one of the panelists that you would like to review, but you don't want to search the entire episode to find it? The additional resources section of the webpage has a complete transcript of today's episode with the time markers for when each question was asked. Find the discussion question on the transcript, and next to it is the time that question was asked. You can either review the comments on the transcript or listen to the panelist's comment on the audio or video recordings. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leaders website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.